So a lot of times people will come to me saying they want a provisional patent. There is no such thing as a provisional patent. I hate to break it to you. That term is used, but a provisional is a patent application. When people are talking about provisional patents, it's not a patent. It's a patent application. It is a place in line, a placeholder. It is our wonderful patent attorney, Brad Brown, uses the analogy of a deli ticket. That's an excellent analogy. It's like you go to the deli, you take your number. The provisional is your number. The non-provisional application that has to be filed within a year after you took your number, after your provisional filing date, your non-provisional is actually something that becomes the patent. But the provisional will never on its own become the patent. It's really just your place in line. But that place in line is very, very important because, as I've said before, it's all about priority. That place in line gives you the peace of mind of knowing that when you go out and you show your invention at the trade show, or you go out and show it to manufacturers reps, or try to get quotes or whatever, you will know that none of those people can steal your idea and get away with it ultimately. If they file an application to try to patent your idea, you will already be in line behind them. I mean, in front of them, so they won't be able to get anything. They'll be blocked by you. If eventually, when you get your patent, let's say they do say, I don't care if you have a patent, I'm going to steal it anyway, which doesn't really happen as much as you might think, because there's some real financial risks to doing that. But let's say someone does that. When you eventually get your patent, you can go back and go after them, and you may not even have to sue them, because you can write a firm letter and they will take it to a lawyer, and the lawyer is going to tell them, yeah, you're in trouble. And so many times that's enough to make them come to the table. But at that point, because you told them that you were patent pending, if they ignore that and they just keep copying anyway, they were on notice. And so that makes them intentional. It puts them in a worse position, let's just say that. Which allows you an easier time to get more damages if you were to sue them. And in any time when you're in a position where you have a good case, you have a solid patent infringement case, and the damages look like they might be pretty high. If that's your situation going into a cease and desist letter, and you can make that clear in the letter, we write the letter, or you write the letter, but in any case, if that's clear, and you send that letter, they then will hopefully take that to a patent attorney who will read it, understand it, and be able to advise them, you know what, this is not a good fight for you. If your case is weak and they have some ways to push back, then it doesn't always go so smoothly, and your settlement won't always follow so quickly. But in a case where you have a strong case and your damages look like they would be pretty high because you have an intentional infringer who was warned years before and just said, I don't care, then their lawyer is going to probably really encourage them to enter into a license agreement early before a lawsuit is filed, to just save themselves a lot of hassle and money. And that's good for you. So anyway, this was supposed to be what's the difference between a provisional and a non-provisional, and I sort of gave you a little extra there. So I hope that was helpful. Just remember, a provisional is not a patent. A non-provisional is a patent. So that's the takeaway. All right, thanks.